Good afternoon, and welcome to Estate Planning Success Secrets, where today we will be discussing the seven biggest mistakes you can make without having an estate plan. Yes, even not having an estate plan will lead to tremendous mistakes. So, without further ado, let us get started. Welcome to Estate Planning Success Secrets with me, your host, attorney Tina Patterson, the principal attorney of Patterson Justice Counsel, PLLC. Today, we're discussing the seven biggest mistakes of having no estate plan at all. So, this means having no will, no trust, no powers of attorney, no nothing. What are the biggest mistakes that can happen? And yes, big mistakes can happen if you just don't make any plans at all. Okay? And so, without further ado, let's begin. Number one is that loved ones may get left out. Okay? There are no natural inheritances for stepchildren. That's number one. We're here in the state of Michigan where I'm licensed. You can check your local state where you are. But and this is very common with a lot of, divorces being on the rise, it's 50-50. There's blended families, so there may be a remarriage. There may be stepchildren involved. Without uh, legally adopting the stepchildren, step parents do not naturally pass on their wealth to stepchildren. Okay, so the stepchildren do not naturally inherit. They can, but you have to purposefully either adopt them, number one. If they adopt them, they have full rights of, biological children, or you can make provisions for them in your will, in your trust. You have to intentionally and specifically include them, or they're automatically excluded. Okay, let me give you a quick example. I was in court a few years ago, and there was a settlement being discussed amongst a widow. Her husband had passed away, a widow, and a company that was apparently held liable for some aspect of his death. Okay, they settled on an amount. I don't remember the number. It doesn't matter the number. Let's just use a round number, $100,000. Okay, these two parties settled, widow and company that was held liable. They settled for $100,000. They agreed that it would go 50-50 to widow and to widow's daughter, okay, who was the deceased husband's stepdaughter. All right. This is on the agreement. The company is going to pay them $100,000. They're going to split it half to widow, half to stepdaughter. The judge excluded the agreement. Why? Because the stepdaughter cannot naturally inherit. Okay, apparently there was no will. There was no estate plan that included her. Father or stepfather never officially adopted stepdaughter. And this was a grown woman too. So she could not, even though the parties agreed to it, the judge did not approve it because she could not naturally inherit. That is the risk you run. Okay, even though this individual had been raised by that father for so long, had been married to mother for decades, could not legally receive her portion of that $100,000. It could be $1 million. It could be $10 million. Okay, if there's not a provision specifically including stepchild, or if stepchild has not been legally adopted, stepchild will get left out. Okay, that's just number one. Number two, grandchildren are not automatically included. Okay, we'll get into that probably the next slide. There are legal provisions about who's entitled to what. If you pass away without an estate plan, without a will, without some kind of writing, without some kind of distribution, there's going to be a estate plan involved. And I know once we get up in age, we've acquired more wealth. We're thinking about our retirement, our endings, right? And our grandchildren, anybody that has grandchildren out there almost knows how precious they are to them. They are not automatically included. Okay. And you can tell whoever you want to that you're going to leave this to the grandchild, you're going to leave that to the grandchild. Put it in writing. It has to be specifically mentioned and included, or else it's really not enforceable the way you are wanting it to. Now, when it comes to wills, when it comes to estate planning, oral agreements, like, saying things, can be legally enforceable, not with property though, not with real property, not with real estate, not with land. Any kind of provision in land has to be done in writing. But let's say you want to leave grandchild the car. Okay, you can say that, but then when it comes down to it, where's the writing for it, right? That's why it's so hard to have that included. So you want to make sure you specifically, intentionally include them with writing in the plan. Okay. And then also close friends, other beloved family members, they can get left out without intentionally including them. All right, because we'll see, I think, in the next slide or two, kind of who is gonna be the natural heir of your property if you don't have a plan. There is a provision for it, there is some kind of planning, but it's not your plan. Okay, and that's why it can be a huge mistake because it may not be who you want it to be to assume that property or who you want to give it to, where you want it to go. Close friends, other family members, if it's a neighbor that always looked out for you, if it is an aunt, if it is a cousin, if it is a church, right? You're very actively involved in the church and you want to leave them something. If you don't specifically make provisions for them in your estate plan, they can get left out. And is that what you want? Or do you want to actively shape your plan and include them just as you did in your lifetime? That is the power of estate planning. That is why it's so important not to just leave it up to chance, okay? Because it's not even up to chance. There is a plan. That's number two, leaving the state to make a decision for you. There is a default. If you do not actively design, it's going to automatically default. And that is going to be up to the state law. Okay, now here in Michigan, uh, if you have, let's take me, okay. Um, if I have a spouse, my spouse is usually going to inherit most of it, 100%, okay? If there's minor children, that can be divided up. But usually it'll go to the spouse first. If there's no spouse, then it'll go down to the children. If there's no children, it'll go up to a parent. No parent, then maybe a sibling, okay? You see how it kind of starts to go out and around until it gets to maybe aunts, uncles, and those kind of degrees. And then ultimately, and this has happened with people getting higher up in age and they're further up in age. I have clients that are in their 90s and they're kind of the last of their kin. If there is no one else blood related to you, there is still a beneficiary, and that is the state. So anytime you don't make a plan, there is always a default as to who's going to get what. And at the end of the line, which is more common than you think, it is the state. That means you can work hard to have all of your assets, acquired over your lifetime. You do nothing with them, and ultimately it's going to go to the state. And the amount, again, we kind of tend to default to the amount, or maybe it's not that much, but it doesn't really matter. And you would think that the more you have, the more you'd be protecting, and that's not necessarily true. I look at the case of Prince, the musician Prince in Minneapolis, obviously a multimillionaire many times over, right? Sold hundreds of millions of records around the world, but was very skeptical of attorneys. So he did not have an estate plan, didn't have a will, and his estate was just in disarray when he passed away. Um, did not have any children, was not married at the time, right? So there goes kind of the natural heirs. If that was the state of Minnesota, let's say if he was here in Michigan, no spouse, no children, parents have already been deceased. Okay, well then who did it go to? And I think it ultimately did end up going to his sister, right? Because then it would go to siblings. But recently his sister passed away, and I don't believe she had any children either. So her brother's already passed, right? Their parents are already gone, no children. I don't believe his sister was married. Who is it going to go to, right? And I haven't kept up with it beyond that, but let's just say if that was here in Michigan, sister has no one else. If they didn't create some kind of alternate plan to where her share would go, like maybe they included a trust and she put all her rights in the trust or something like that, the state, the state is the ultimate beneficiary. Okay, we're using that scenario and applying it here in Michigan. And again, that could be also the same rule in Minnesota. You have to check your state. But ultimately, there is a beneficiary, and the ultimate beneficiary is the state. All right. So aside from that, just allowing the state default plan to guide your affairs, it may not be what you actually desire. So even if you do have a living heir. Okay, let's say you're widowed and you have three children and you got along great with two of them, but one of them was kind of distant. Still loved them as a child, but they were maybe not even the problem child, like stayed in trouble, but they were just so temperamental that you just kept them out of things. And you knew that, but you never made plans and suddenly passed away. Well, guess what? Now that child has a say so. And those three heirs, are they gonna divvy out what it is according to your plan, right? Let's go to number two. Again, the default plan may include others you wish to exclude and vice versa. Exclude people you wish to include. We just talked about this stepchild provision, okay? So if you don't make the plan, if you don't intentionally include them, then they're excluded automatically by default. Same with, again, causes you care about, if you give to charity often, or if you donate to the church, if you're very active in the church, maybe there's even a church member that you support and you wanted to leave something to, but you never put it in writing. That is off the table now, according to this plan, okay? The default plan. And then finally, at the end here, we have the plan is less flexible, but more time intensive and costly to the estate. Why is it more time intensive? Because you have to go to court. Probate court is not an option anymore. If you make no other choice and you just leave everything in your own name and you have no beneficiaries listed, you have to go to court to change those names over. That's how the estate gets opened. That's how the estate has someone named, usually the executor you might have heard, or personal representative, right? They have to be the person over the estate that can make decisions and pay creditors, make distributions, pay attorney fees, right, for representing them, representing the estate, pay administrative fees, taxes if there are any taxes, okay? And trust me when I say taxes is the least of the issues, all right, when it comes to this kind of estate planning. Uh, Taxes really don't come into play until it's over the taxes you may hear about when it comes to estate planning, the federal estate tax when it's over $13 million. Okay, so we're talking about that for all intents and purposes right now. But it is more time intensive just because the court process has to take about 6 months minimum, usually here in Michigan, and that is for the inventory to be counted for. That is for the creditors to make their claims. They have a 4 month window that has to stay open. Okay. Um, and when you just kind of leave it up for grabs, people fight over it. So let's take that example of the mom and the three kids, right? One of them was kind of distant because they were just temperamental. Well, now they're going to come in and bring that into court and they're going to want to fight it out. And that happens and it drags on. And it doesn't have to be like that if you put a proper plan in place. And why is it costly to the estate? Because it eats up money representing the estate. It eats up attorney fees. It eats up court fees. It eats up administrative fees. If you have to put the property out for sale, right? You're talking about just um, not just real estate fees, but like maybe agent fees, appraisal fees, like all kind of stuff. It just adds up. It just adds up, and all that money is exhausted before it can even get to an intended beneficiary, right, or someone entitled to it. So even if you do nothing, the state has a plan for you. You do not want to leave the decision to the state because it may not be the plan you wish. Number three, open assets to probate court that can and should be avoided, right? So we talked about in the last slide that if there's nothing, you have no plan, you have no beneficiaries, you must go to court. And everything will get included in the estate. So that means everything will become a probate asset. Now let's define a probate asset. Anything held in the name of a single individual. A bank account, a house, a car, a stock account, a retirement account, a life insurance policy, right? Anything that they own personally, jewelry, coin collections, fur coats, right? Anything that has some kind of value like that and it was theirs. That is probate asset. That's now probate asset. Uh, so then if there are probate assets, there are also non-probate assets. What are non-probate assets? They don't have to go through a probate court process because somebody else can inherit that quickly. And usually you see these on bank accounts, life insurance policies, stock accounts, retirement accounts, right? You can designate a beneficiary. That means you can say, hey, let's say right here with the savings account. It is my account, but if anything happened to me, I can name my daughter, excuse me, to take over 100% of whatever is in the bank account upon my death. All right. And once you do that, it bypasses the probate court completely because it's no longer my money. It is the beneficiary's money and they can take all of it. It does not have to go to court. All right. Very, very simple mistake, but this happens all the time. In amounts of $80,000, 100,000, $750,000, right? Again, we kind of think it's just little stuff. It's not. And it doesn't matter the amount. It doesn't matter how much the estate is worth. These mistakes happen in all kinds of situations, okay? So you definitely want to name beneficiaries on anything you can, particularly, again, the bank accounts, the life insurance policies, because they're designed for someone to take over once, you can't anymore. All right. Again, we have here simple mistakes, right? They cost time, they cost money, they cost opportunity. because then they're swallowed up in the probate assets, right? They're swallowed up in the court fees and the attorney fees, administrative fees that cost time. Once again, at least a minimum of about 6 months just to get through the court process. Opportunity because those beneficiaries don't get the money right away that you intended them to have, or you could have intended them to have. Okay. And then three, we have here again, can be caught up in probate and unintentionally even go to the wrong person. So let's take the mother and the three kids again. Let's say mother passes away. She had a savings account. Let's just say she had, again, $100,000 in the savings account. She did not even talk to the one child, right? So let's say if she had named beneficiaries, she would have only named her other two children. Maybe they would have split 50-50, right? Or maybe she knew that one needed the money more than the other, or one could be trusted with the money more than the other, and they did 75-25, right? But the third person would get zero. And that would be the end of story. But because there was no beneficiary named on the account, now you have $100,000 up for grabs. That third person is entitled to some of it, but is it even going to be $100,000 three ways? Probably not. Okay, depending on how much has to go into court fees, attorney fees, that could be just $20,000 off the top. So now you have $80,000 left to split instead of 100,000. Okay, and again, caught up in probate and unintentionally go to the wrong person. So even if uh, they're not even splitting like between the two, that 80,000 anymore. It's between the three because the wrong person is involved because there's been no plan. Okay. Number four, fighting over what to do while you're still alive. People don't really consider this one much, but this happens as well. So in the case of serious illness that causes an inability for you to make your own independent decisions, your family may disagree on how to care for you and to provide for your needs. Okay. When this happens, the benefit of estate planning is that it can be proactive. So it can help cover this situation before it happens with powers of attorney. Powers of attorney are very powerful, right? It's in the name. Documents, and they're not just documents, they're authority that you give someone else um, over your financial matters and over your healthcare matters if you can't make the decision for yourself anymore. So we have the two different types. We have financial power of attorney, which you also hear as a durable power of attorney, and then you have the healthcare power of attorney, okay, which you also might hear as a patient advocate. These are very, very useful tools that you execute while you are still alive, while you are in your right mind, right? You're over 18, you have a sound mind, you know kind of where you are with your property, who would naturally inherit, and you delegate someone you trust to be named that power of attorney so that if anything ever happened to you, let's say we have this picture here, if anything were ever happen to you like that, where you were just kind of in a coma, you couldn't make your own decisions, you don't even have to worry about it because this person that you trusted is able to make those decisions for you while you rest and recover and heal. Okay? And they work hand in hand because let's say worst case scenario, you happen to pass away. Well, power of attorney is ineffective, but this is where the will takes over. Okay. This is where maybe trust provisions take over. This is where the remainder of the estate plan takes over. Because powers of attorney are only good for life. But people often forget that because there are still decisions that need to be made while you are alive. And obviously, you're the one to do it. But are you always going to be able to, just based on the circumstances or situations? Okay. And it may just come out of the blue. You might not even know what happened. Just this is February 2025, halfway through it. Just in this year, not even a month, I've already had clients, suffer major debilitating medical conditions. Did they plan for it? Like, were they expecting it to happen? No, not necessarily, right? But powers of attorney will help fill in those gaps when they happen because we can't always predict everything that's going to happen in life, right? But we can prepare for it. So that's why powers of attorney are so important. So we can avoid this fighting, this disagreement over what's going to happen to you while you're still here. Okay. Otherwise, number two, let's go to number two. Disputes must be handled again by probate court through processes called guardianships and conservatorships. The guardianship court process is over your kind of physical well-being, your healthcare well-being, who can make the decisions for that, how can they use the money for that, etc. Conservatorship is for your finances, okay? Your bank account, your income, your businesses, your real estate. The process is for somebody to be named to take over that. And let's go to number three. These are big hassles of time and money, easily prevented with proper planning tools such as powers of attorney. Okay, you can follow us for more information on this. I've talked about it extensively on my YouTube channel at Patterson Justice because um, the guardianship and conservatorship procedures are very time intensive. Again, a lot of hassle. This is where a lot of fights can happen because family may not agree over, what's going to happen with mom. And then the court has the power to appoint independent agents to act instead of family, right, who knew them best. And that's when it really gets sloppy and messy. And in addition to all of the filing, all of the accounting, keeping up with receipts and documents, it is just a big hassle. Big hassle, big time cost, big expense cost too, that can easily be avoided with powers of attorney, which are an estate planning tool you can put in place yourself. All right. Number five, we have here confusion amongst grief. What does that mean? You leaving your family to figure out a plan while mourning you and to figure out what to do. Number one, immense grief over a loss of a loved one is difficult enough. Okay, when you just lost a parent, when you just lost a child, when you just lost a spouse, that is a very big emotional weight on you. You're not thinking about, okay, well, what's gonna happen, right? You're trying to figure out what's gonna happen to you, right? What's gonna happen to you now? How is your life gonna change now? Because it's drastically changed. What are you gonna do? How are you gonna move on, right? Sometimes you might not even feel like you can get up and go on, but you're still alive, right? So you're just fighting for that. Imagine, right? I'll just say I had a situation where a father, right, passed away, left his daughter, didn't have a plan. This father was a real estate investor, had 20 properties. So imagine, here you are. Let's look at this picture again. You're grieving your father, right? The person that cared for you, provided for you, protected for you your whole life. You lost him now. You don't know what to do. And now you got to worry about what's going to happen to these 20 properties he got, right? Because you're the heir. So it's going to fall on you. Who's got time to think about that when they just lost a father, right? You can't even grieve properly because now you're just trying to, oh my gosh, think about what are you even going to do about these properties? Okay? That's number one. Number two, we have no plan for your affairs causes confusion over the process while still grieving. Again, confusion because you just don't know what to do. Or maybe if there's two involved, one has an idea and one doesn't. Or they might have two different ideas, right? They might come to a head. So now you have confusion, contention, there's conflict, and this just happened. And it happens like this almost just as soon as death occurs. I mean, and it can drag out unnecessarily, and it doesn't have to. And then also there's number three here. You have an uncertainty of finances, documentation, location, sometimes while still planning a funeral. So, maybe hey, mom did leave, $10,000 to cover the funeral costs, but I don't know where it's at. Or yeah, she had a life insurance policy, but I don't know where it is. I don't know what company it is. I've had clients where, their parents have had life insurance policies, but they don't know the company. They don't know the amount. They don't know the beneficiaries. And let me say this while I'm on it, and I'll probably say it a little bit later, but life insurance policies, tell somebody. And if you don't want to tell the person that is entitled to money, tell somebody you trust who the beneficiaries are. Okay? Because if you do not know, same thing with bank accounts, tell somebody. If you do not know, or if once you pass away, nobody knows how to find this information, it has to go to probate court. Okay? Because they have to then gain the letters of authority to act on your estate's behalf to then go to life insurance company and say, hey, this is the information I need. Can you tell me who the beneficiaries are? And that's just an unnecessary step as opposed to whoever the beneficiaries are going directly to the life insurance company, going directly to the bank, right, presenting their ID, the death certificate, and then just claiming the funds. That can be done 30 days or less. Again, going to court to do all that, who knows? Okay. It just saves the time and saves the grief, saves the hassle, saves the confusion. Number six here, we've kind of alluded to it, but I want to hammer in on it. Division and disagreement between families, okay? Arguing over who gets what. And look at this chokehold. It's real. It's real, okay? It might not always come to, the physical here, but I'm telling you, That family division and dissension is very difficult to overcome. All right. Because as soon as mom, dad, right, it's usually the last surviving patriarch or matriarch of the family. As soon as they come, to glory and they go on and transition, the fights start. The siblings go at it. I mean, and these are grown siblings. It happens in so many different scenarios too. Arguments over who should get what. We'll go into it. Fighting over direction of control, right? Like who's going to be in control, who's going to be this. Well, mom wanted this person. The will, if there's a will, said that person. We're talking about no will at all, though. So well, maybe this person lived with mom. This person was close to, right? We don't know. This is number three that I really want to get into, though. Exerting control by a dominating personality. In many different scenarios, I have seen it where there have been multiple siblings, usually at least four, okay, between four and six. There's always one that doesn't get along with anybody else. There's always one that just has this need to control. There's always one that just needs to dominate. They have to dictate what's going to happen. They have to be in control. They have to be the one. And all of the other siblings are on one accord. It's only this one, and it's only that one that takes it and just blows it up. Why? Because when it comes to just leaving no plan at all, um, again, you have to go to court, and that one is ready to go to court and fight it out to the death. And it doesn't need to be that way. It does not need to be that way. Okay? Because often the other ones are not even trying to exclude. They're just trying to all come together in agreement, and this one does not want to agree. They want to lead the charge, and they want things their way and only their way. Okay? And it's almost like defeat if they would agree to agree. Do not do this. Make a plan so that you don't bring your family to this, because I'm telling you, once that peace and trust is broken, it's almost irreparable. All right? Finally, number seven, care of dependents left up for grabs. This is especially important. Let's go down to number three for single parents and caregivers. All right. Why? Because if you are a single parent, maybe you're divorced, maybe you were never married and you have a minor child, um, who's going to take care of that child after you? Right? Is there some kind of provision in the divorce decree, where the ex-spouse will have some custody control? You might want to look at that. But if you're never married, and let's say, mom or dad was never involved, well, then what's going to happen? And caregivers, because I've had adult um, clients as caregivers of their adult children, right? Maybe their adult children had some kind of mental disabilities. They had some kind of just mental deficiencies where they needed to become their guardian. Well, if you do not have an estate plan, you don't have a plan for who's going to be the guardian of that child. You don't have a plan for who's going to take over as a single parent once you're gone. You don't have it in place. It's not there. So, number one, with no guardian name for will for minor children. This is one thing a will can only do. A will can name guardians for your minor children. Okay, a will can name guardians for who's going to take over for you as a caregiver if you have guardianship over, your adult children, like I mentioned. Okay, again, number two, same for guardians of disabled adults, adult children who you've gotten guardianship over. And it may be for just protective purposes, okay, but it's very important that you do not leave these gaps out there, because you know that you're responsible for somebody else. So you know that it's all on you. It's gonna all fall on you. Make sure you delegate that when you can't be there to do it anymore. All right. That's the significance of planning, is that you can make that happen. And you never plan out of fear, never plan out of thinking that, oh, well, uh, it will never come to that. You plan out of preparation. Okay. So that is the end of the presentation. Here are our services. We're dedicated to your generational success. All right. Don't go at it alone. With our help in proactively addressing these critical areas, you can secure the future of your wealth for your family and provide peace of mind. And I want to remind you that we are doing a masterclass soon, the Lock in Your Legacy Masterclass, the estate planning essentials. Okay. We're doing a 3-day masterclass. 2 days is general admission. The third day is an important VIP day. The general admission is a $4.97 ticket. The VIP is a $9.97 ticket. You get an exclusive training and also Q&A sessions as well as a bonus additional training. Okay. That is going to take place on February 27th and the 28th from 10 a.m. to 11 a.m. And then we're going to have a Q&A from 11 to noon. And then the bonus VIP is also from 10 a.m. to 12 p.m., including a Q&A. All right, so do not wait until it's too late. Take the first step towards your peace of mind. It is worth it. Join our estate planning masterclass to learn how to create a plan that meets your unique needs and secures your legacy. And with that, again, my name is Attorney Tina Patterson, the Principal Attorney of Patterson Justice Council, PLLC. This is our contact information. We're particularly active on LinkedIn and YouTube. Follow us there for more information, and we look forward to sharing more of our estate planning success secrets with you soon. Thank you very much and take care.